Thank you very much, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Amend the Bail Act, Chapter 4, Number 60, be now read a second time. Before I get into my substantive comments on the clauses of the bill, Mr. President, permit me to make a few prefatory remarks as I introduce this bill. Firstly, the decision of the Privy Council in the case of the Attorney General and Achille Charles, 2022 UKPC, page 31, was delivered on the 28th of July, 2022, and significantly followed shortly after the reasoning of the decision of this board, the same Privy Council, in Suraj and the Attorney General, 2022 UKPC, page 26. And Achille Charles proceeded to apply the reasoning of the Suraj decision with respect to the issue that this bill addresses today, that is to say, the entitlement of citizens of this country to bail. Secondly, Mr. President, and of course, I will discuss the Achille Charles decision in some detail, but I consider it important to state from the outset two significant points which emerge from that decision. On the first principal issue which was before the board, whether the bail provision in the Act then being challenged, the 1994 Bail Act, was an existing law under Section 6 of our Constitution. In holding that it was not an existing law, the board of the Privy Council underscored a very important common law position dating back to 1898, and the decision of the Queen and Spilsbury. And I quote from the Privy Council decision in Achille Charles in that regard. This court has, independently of statute, by the common law, jurisdiction to admit to bail. The court or any judge on vacation, not being restrained or affected by statute, in the plenitude of that power which they enjoy at common law, may, in their discretion, admit persons to bail in all cases whatsoever. The point emerging here, which has been emphasized by Achille Charles, and which we salute and pay respect to, Mr. President, is the proper respect which must be had to the judicial discretion which this bill respects, and by the provisions of this bill is asking this House to legislate to provide guidelines for. And the decision in Achille Charles, Mr. President, endorsed and accepted the Court of Appeal reasoning of this jurisdiction. At paragraph 37 of the judgment, the Privy Council stated, the board therefore agrees with the Court of Appeal that at common law, there was no existing law prohibiting the grant of bail in murder cases, either pre or post-committal. And I emphasize the point because there are some of us in this society who continue to think that the only judges who are capable of applying law are the members of the Privy Council. I emphasize the point that the significant decision in Achille Charles, for all its reasoned decision, the board accepted, endorsed, and embraced the rationale and the reasoning of the Court of Appeal of the Supreme Court of Trinidad and Tobago. On the second principal issue, with reference to which the board in Achille Charles had to apply Section 13 of our Constitution, the board reminded itself of the now refined and applicable proportionality test as defined in Suraj. Mr. President, in examining and discussing this bill today, it is useful to remind ourselves as parliamentarians, that is to say, members of this honourable chamber, of the powerful reasoning of the board at paragraph 56 of the Achille Charles decision, and I refer in that regard to paragraph 56, subparagraphs 1, 2, 3, and 4 of that decision, which state, and I quote, One, the onus is on the complainant to show that the measure is not reasonably justifiable. That is to say, the measure proposed by the draft legislation, the bill. This places a heavy burden on the complainant, and a court will be slow to conclude that this has been shown. Secondly, Achille Charles states, the test of proportionality appropriate under Section 13(1) involves a lesser intensity of review by the courts and a wider margin of appreciation or discretion for the state acting by legislation passed by a supermajority in both chambers of Parliament. Thirdly, in relation to such legislation, Parliament will have identified in a particular clear and forceful way its opinion as to where the public interest lies. I pause there to emphasize and to repeat, because we are the Parliament of Trinidad and Tobago. We are the Senate chamber of the bicameral Parliament of this chamber and the other place. In relation to such legislation, Parliament will have identified in a particularly clear and forceful way its opinion as to where the public interest lies. In a democratic state, the courts must be expected to be especially respectful of the choice made by Parliament to pass legislation in that form, and slow to substitute their own view of the necessity for and proportionality of the measure taken. Fourthly, although the court has to make the ultimate judgment whether the proviso in Section 13(1) has been satisfied or not, it is obliged in doing so to give especially great weight to the judgment of Parliament regarding the importance of the public interest which is sought to be promoted by the measure in question. I've read from 4 paragraphs of the judgment of Achille Charles, and in those 4 paragraphs, twice the Privy Council repeats its focus on the role of Parliament to determine what is in the public interest of the democratic country of Trinidad and Tobago. And what we are here about today, Mr. President, is the public interest of securing the safety of our citizens from crime, and in particular, crime constantly being committed by repeat offenders who are given bail and come back out to continue to perpetrate their dastardly deeds on an unsuspecting innocent citizen. And the point which I wish to emphasize, emerging from Achille Charles and relying on the Suraj decision and applicable now to this bill, applying the reason of the Privy Council, which I have just quoted from, is that it is for this Parliament, Mr. President, members of this august chamber, in our consideration of this bill and all that I will place before this chamber today, to apply the proportionality test framed in a way which gives especially strong judgment to our decision in Parliament regarding the imperative nature of that public interest. To identify in a particularly clear and forceful way its opinion, Parliament's opinion, as to where the public interest lies. So that it is for us today, Mr. President, as responsible senators, to accept our mandate conferred by Section 40 and 53 of our Constitution as legislators in these challenging times to pass constitutionally compliant legislation, whether by simple or supermajority, tailored to protect and serve the public interest. Reminded of the injunction of the Privy Council that, and I quote, in a democratic state, the courts must be expected to be respectful, especially respectful of the choice made by us, I interpose, in Parliament to pass legislation in that form, and, I interpose, by a balanced and appropriate exercise of our discretion and respecting the decision of the judiciary dating back to 1898, the courts must be slow to substitute their view of the necessity for and proportionality of the measure taken. Mr. President, the passing of this bill today, which this government puts before this chamber, is the point of opportunity for us as responsible members of legislature to have confidence in ourselves to do our job, to pass this amendment bill in the public interest, and equally to have the confidence in our judges exercising their ancient 1898 discretionary jurisdiction to respect and to interpret this amending legislation with appropriate balance, as the Privy Council has reminded us in Achille Charles. Accordingly, Mr. President, by the presentation of this bill for debate and passage today, it is the intention of this government, one, for this chamber, constituted as it has been under the mandate of the Constitution, Section 53, to make laws for the peace, order, and good government of Trinidad and Tobago, and by the first amendments to the Bail Act, and I stress that, the first amendments to the Bail Act brought before this Parliament since the 28th of July 2022 decision to pass this bill in recognition and affirmation of that Achille Charles decision. And that decision has affirmed the confidence of the Privy Council in the correctness of our judges of Trinidad and Tobago, our Court of Appeal, and the discretion of our judges to exercise their ancient judicial discretion to grant or refuse bail in accordance with well-established common law principles. So that the guidelines which by this bill we ask Parliament to pass into law, serving the public interest, are guidelines to assist our judiciary in serving that public interest, to get the balance right in the conditions and the exercise of their discretion as to when or when not they will grant bail on applications brought before the courts for that bail to be granted. It is the intention of this government, Mr. President, to introduce, therefore, legislative guidelines with respect to the grant or refusal of that bail for serious offenses, unless the accused can prove to the satisfaction of the court that his continuation in remand is not justified, because he, as the applicant before the courts, can show sufficient cause or exceptional circumstances why he should be granted bail. Otherwise, the courts will say, no, you must remain there until your trial comes up. Thirdly, as part of this government's continuing commitment to make laws for the peace, order, and good government of Trinidad and Tobago citizens, we wish to introduce, and we have been over the last several years, Mr. President, and this piece of legislation, this bill, is but part of that tapestry which this government has been putting onto our law books to introduce a more expeditious criminal justice system to facilitate expeditious judgment and justice. And in that regard, I cite as one of the more recent examples the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, a JIPA, which has accomplished, among other things, the abolition of preliminary inquiries, which have been a blot on due process and respect for fundamental rights and freedoms. There are cases in our courts today which are still in year 13 of the preliminary inquiry process, and a JIPA has been introduced by this government out of respect for the rights of accused persons who are in remand awaiting trial, to stop that insufferable delay in the delivery of justice and give them their right to a fair trial in an expeditious period of time. And in that period of time, if they can satisfy the judiciary that there are exceptional reasons why they should be granted bail and put back out into society, so be it. The court will have exercised its jurisdiction. But if they are not able to satisfy the court that exceptional reasons exist why they should be released back onto the society while they await trial, they shall remain on remand. Mr. President, the Achille Charles decision is of major significance since it was settled on the 20th of July. Prior to that decision, Mr. President, the offense of murder was one of the non-bailable offenses listed in Part 1 of the first schedule to the Act. And we've seen that the Privy Council has said that that non-bailable aspect of murder was contrary to the common law and therefore unconstitutional. So as a result, the Privy Council declared that Section 5.1 of that 1994 Act was unconstitutional. And the Privy Council declared Section 5.1 to be unconstitutional as being disproportionate because what it introduced in 5.1 was a blanket approach. And one of the examples which is given in the Privy Council decision of Achille Charles, one of the cases that they considered in arriving at the decision to find that bail was not, the denial of bail was not constitutional, is a very good practical example. You can have two people on trial for murder. One who is an accused terrorist who has just blown up 100 people. That person is in remand awaiting trial for a serious offense and applies for bail. Another person is also on remand for bail because he or she is a partner of someone who was terminally ill and participated in what is known as a mercy killing. So that person is now also charged with murder, and that person is also on remand. The blanket approach to deny the judiciary the exercise of jurisdiction to be able to say in the case of the person on trial for a mercy killing that you are not allowed bail because no bail must be allowed for anyone charged with murder is what the Privy Council found to be disproportionate, because you cannot apply that blanket approach to everyone charged with the bail. The alleged terrorist justifiably should remain in jail because of the fears of what he may do if he's released back onto the society. But someone who, out of compassion, living for years with her partner or his partner and unable to deal with the agony of seeing that person continue to suffer, bedridden for years, does what the law refers to as a mercy killing. And are you going to say that that person must remain in jail for the 5 years it takes for the trial to come around? The Privy Council said, no, that is wrong, that is disproportionate. That was one of the examples that was looked at by the Privy Council in the Achille Charles decision. So the Privy Council has told us, Mr. President, that the objectives which are being achieved must be achieved by less intrusive means. And the board explained that instead of removing the court's discretion altogether, conditions in relation to that 1994 Act could have been introduced by Parliament to guide the court's discretion. And that is exactly what we are asking the Parliament today to do. To introduce, respecting and recognizing the decision of Achille Charles that bail is, the denial of bail, the blanket approach is unlawful. We are asking this court today to pass a bill which will introduce conditions by which the judicial discretion dating back to 1898 can be properly exercised in balanced terms, in other words, in proportionate terms. Mr. President, we accept that the effect of the board's ruling is that persons now have a right to apply for bail, but not a right to be granted bail. You have the right to apply to the judge And you must now satisfy the judge if we, in our legitimate, proper exercise of our legislative authority today, pass this bill into law. You have the right to apply for bail, but the judge will determine on the particular facts and circumstances of your case as an applicant whether you have an entitlement to be granted that bail or not. Mr. President, in preparation for presenting this bill before this House today, I asked the Law Reform Commission, a very resourceful part of the Ministry of the Office of Attorney General and Ministry of Legal Affairs, to consider and advise upon the specific issues and any other pertinent issues to the reform of the Bail Act. And the Commission did a number of things. One, they examined the bail legislation in other Commonwealth countries to take guidance from those other jurisdictions, including England, Australia, Canada, South Africa, and New Zealand. Secondly, they gave due consideration to the constitutional rights and freedoms of an accused under sections 4 and 5 of our Constitution, and to the relevant jurisprudence which provides guidelines on how those rights are to be treated and respected. Thirdly, they considered recent legislative developments which have had significant impact on the granting of bail, particularly in relation to the offense of murder and other serious offenses. And fourthly, they considered the crime situation in Trinidad and Tobago, particularly the commission of serious offenses, including murder, gang, and firearm-related offenses within the last 5 years. And in consequence, Mr. President, the Commission recommended that the Bail Act be amended, 1, to give to masters of the Supreme Court the jurisdiction to grant bail for the offense of murder, where before masters had no such jurisdiction. 2, to provide that a person charged with the offense of murder may be granted bail if he can show that there exist exceptional circumstances why she or he may be granted bail. And this assists and gives support and guidelines for the exercise of judicial discretion, applying the principles of Achille Charles, recommending that instead of the absolute ban imposed by the legislation of 1994, Parliament could have imposed conditions on the exercise of the court's discretion. I've already dealt with that. Thirdly, they recommended the repeal of Part 2 of the first schedule of the Bail Act and to substitute a new Part 2 setting out the serious offenses which will attract enhanced bail restrictions. Fourthly, they require a judge or master, and this is important, Mr. President. The recommendations of the Law Commission were to require, by parliamentary provision, which we will pass today, it is my hope, require a judge or master to give to the accused and the prosecution reasons for their decision to grant or refuse bail or to impose conditions on that bail in criminal proceedings originating in the High Court. There can be no more transparent, fair process for anyone if a decision is made affecting your rights to be told, these are the reasons why I have arrived at this decision. Because it gives you the opportunity on the existing and undoubted right of appeal, which is the fifth recommendation of the Law Commission. It gives you, as the accused person, applying for bail and having had your bail refused, you have the reasons. You can go to the Court of Appeal and you could point to one or more of the reasons to say that reason is erroneous in point of law or erroneous in point of fact in relation to me, the person who made the application. That is what is known as due process and the protection of the law. So the recommendations of the Law Commission to me, put forward now in the bill before this House, provide reasons, judges and masters, and give to the accused and the prosecution the right to go to the Court of Appeal to challenge that decision. And the sixth recommendation of the Law Commission, Mr. President, was to introduce enhanced bail restrictions guiding that judicial discretion with respect to persons charged with specified serious offenses, or where a firearm or prohibited weapon or imitation firearm was used or in the possession of the accused or any other person involved in the commission of the offense. Mr. President, consideration has also been given to the following recent developments which have had significant impact on the granting of bail, particularly in relation to the offense of murder and other serious offenses. The Commission took note of the fact that there have been a number of different attempts in this country to pass bail legislation which have expired either by effluxion of time or by the arrival of the sunset clause. All of that was considered in the round as they sat to the task of making recommendations, which recommendations were then taken to the Chief Parliamentary Counsel, who has the responsibility in the Office of the Attorney General and the Ministry of Legal Affairs for the drafting of legislation. And therefore, Mr. President, we have a situation now by which we have come to this Parliament with the bill before the Parliament. And one of the matters that the Law Reform Commission addressed was the tangible concern that under the current bail regime, there is the rare likelihood that repeat offenders of serious offenses will continue to obtain bail unless we, the parliamentarians, do something about that. And the work of the Commission, Mr. President, interrogated and took into consideration by research and policy advice to me as the Attorney General, the high levels of crime in Trinidad and Tobago, particularly the commission of serious crimes, serious offenses including murder, gang, and firearm-related offenses within the last 5 years. And they provided me with statistics that I provided to the draftspersons for the drafting of the bill, which is now before this House. So for the period 2019 to 2024, Mr. President, the statistics which were obtained from our various law enforcement and national security arms of the state tell us that the Trinidad and Tobago Police Service has identified 772 persons as being repeat offenders. Data provided by the Commissioner of Prisons tells us that out of a total of 2,261 convicted male offenders in 2019, there were 1,110 repeat offenders, which represented 49% of the total of all male convictions in that period. In the following 2 years, that is to say, in the heart of the pandemic, there was an average decrease of male convicted repeat offenders by 10%. Thank God for the pandemic, if one could ever say that. But towards the end of the pandemic, in 2022, there was an increase of immediately 5%, that is to say, 451 instances of repeat offenders out of 1,366. And in 2023, the percentage of reoffenders had surged from the 5% in 2022 to 52%. That is to say, 1,076 out of 2,070 convictions. And in the period 2022 to 2023, the year just preceding the year in which, by the grace of the Lord, we now live, that is to say, 2022 to 2023, there was a 139% increase of convicted male reoffenders. The data also reflects a steady increase in the number of male convictions for firearms and dangerous drug offenses following the COVID-19 pandemic. And this government, Mr. President, is therefore of the view that it is necessary, it is imperative for Parliament to intervene, to introduce conditions to guide the exercise of the court's discretion to grant bail to persons charged with serious offenses, including murder, by requiring such persons to show sufficient cause or that exceptional circumstances exist to justify granting bail to them, particularly in the face of a continuing percentage increase in recidivism. That is to say, the ability of offenders to repeat their offenses once they are back out on bail. So the Bail Amendment Bill 2024, which is before this August chamber, Mr. President, that bill contains 9 clauses and requires a 3/5 majority vote pursuant to Section 13(2) of the Constitution because, acceptedly, some of the proposed measures introduce restrictions on a person's right to reasonable bail. What does that mean? What does a 3/5 majority vote mean? It does not mean, as I have heard to my dismay many times in this Parliament, when the United National Congress opposition comes to speak with it, it doesn't mean that because a bill requires a 3/5 majority, that by itself is a reason to vote against the bill. The requirement for a 3/5 majority is not a reason to say, because it requires a 3/5 majority, I'm voting against it. What it means is that we must look at the data and the facts which I have presented in this case, or are presented otherwise, before the Parliament, to show the threat that exists, the dangers that exist, the public interest that must be served, and the measures which this Parliament can take to intervene, to introduce controls, to save the society, innocent men and women, young girls coming from school, young women going to work, many of whom work on shift and are coming from work at night or going to work at night, to save them from the scourge of repeat offenders. That 139% increase in 1 year, the period 2022 to 2023. So when the opposition comes today to vote, they must reflect on that. Are they here to protect young, innocent people, the elderly and the infirm, and the other citizens of this country from a preventable scourge of crime, or will they throw their hands up and say, we are not voting for it because it requires a 3/5 majority? Nonsense, baloney. The purpose of this bill, Mr. President, is to amend the Bail Act to make provision for the restriction of bail to persons charged with serious offenses, to provide guidelines, not to deny bail, to provide guidelines for the judges of our country to determine, when an application is before them, whether the applicant has shown good sufficient cause or exceptional circumstances why that applicant ought, in the discretion of the judge, a discretion that existed, that the Privy Council has determined since 1898, to determine whether that bail should be granted. The bill seeks to introduce conditions, therefore, Mr. President, for the exercise of the High Court's discretion in granting bail for persons charged with murder, serious offenses listed in Part 2 of the bill, and for other offenses, firearms offenses. And if one can just give an example, Mr. President, of the serious offenses listed in Part 2. Serious offenses specified in Part 2, just so that we don't have words that can be passed on as if they mean nothing. A, an offense committed by a person over the age of 18 years under the Anti-Gang Act 2021, which is punishable by imprisonment for 10 years or more. B, an offense under the Offences Against the Person Act, punishable by imprisonment for 10 years or more, or an offense under Section 48 of that Act. C, an offense under the Dangerous Drugs Act, punishable by imprisonment for 10 years or more. D, an offense under the Kidnapping Act, which is punishable by imprisonment of 10 years or more. E, an offense under sexual offense under the Sexual Offences Act or the Children Act in which the alleged victim is a child. So when we come to vote today, let us reflect on that. Let the public reflect on that as they judge how this vote goes. The capacity of a judge with proper guidelines, where the person before her or him is for bail to show good, sufficient reason, exceptional circumstances why they should be allowed back out to continue to rape children. That is what this bill is about. F, an offense under the Sexual Offences Act punishable by imprisonment for 10 years or more. G, an offense under the Anti-Terrorism Act, which is punishable by imprisonment for 10 years or more. H, an offense under the Trafficking in Persons Act, which is punishable by imprisonment of 10 years or more. Trafficking in children. Those are the offenses that have been committed in this society, Mr. President. And H, an offense under the Firearms Act, punishable by imprisonment for 10 years or more. So when we go to look at the bill and we look at the term serious offenses, these are the offenses that we are talking about. So it's murder, serious offenses, and firearms offenses. And the bill, therefore, seeks to impose a reversal of burden on the persons charged with those offenses, murder, firearms-related offenses, to require those persons to show exceptional circumstances or sufficient cause to persuade the judge to justify granting them bail to be released back into society while they await trial. Mr. President, the case that was cited by the Achille Charles decision, which I referred to earlier, is actually a Trinidad and Tobago case. It's not an occasion of what occurred here, but they used it as an example. It is a case of Boudram, an Attorney General of Trinidad and Tobago, determined in the Privy Council. And at paragraph 30 of Boudram, this is what the Privy Council said in relation to the crime of murder. The crime of murder is, of course, always very serious. But some murders are more serious than others. The circumstances of murder cases vary across a wide range, from the terrorist who aims to overthrow a state by killing as many of its citizens as possible, to the devoted partner who commits a mercy killing in order to end the unbearable pain suffered by a loved one who is terminally ill. That was the example given by the Privy Council when they ruled, as Achille Charles did, that a blanket approach to bail was unconstitutional because you have to weigh the different circumstances into account. And the bill also seeks to provide a provision for a review of the act to be conducted every 5 years after its commencement. And finally, the bill seeks to provide that bail granted to an accused under Section 5 of the Act, proposed to be deleted and substituted by a new subsection 5, will continue to apply after this amending Act comes into operation. Clause by clause, Mr. President. 1 to 3 speak to preliminary matters. We remind ourselves of the Queen and Spilsbury dictum that the judicial discretion has existed since 1898. And the new subsection 5, Mr. President, which will firstly accept that a magistrate will continue to have jurisdiction to grant bail for summary offenses. Secondly, will grant to a judge and master the express jurisdiction to grant bail to a person charged for murder in those exceptional circumstances or sufficient cause. Thirdly, offenses listed in Part 1 of the first schedule will continue to be non-bailable offenses. So murder is removed from Part 1, but the offenses of treason and piracy remain. Those remain non-bailable offenses. Fourthly, a judge and master will have the jurisdiction to grant bail for indictable offenses except those listed in Part 1 of the first schedule. And fifthly, as seen in the proposed Section 3, a judge or master may not grant bail to to a person who, on or after this bill becomes law, is charged with an offense under Part 2, that's the serious offenses, those would be carrying imprisonment for 10 years or more, and he, A, has a previous conviction for any offense punishable with 10 years or more, and B, has a pending charge for an offense listed in Part 2, unless he can show sufficient cause or exceptional circumstances. And in relation to that exercise of discretion, Mr. President, the judge's ancient discretion is preserved. Mr. President, I could continue at length. I have looked at a number of different jurisdictions in India, for instance, Section 35 of the Narcotics, Drugs, and Psychotropic Substances.
Attorney General, you have 5 more minutes.
Thank you very much, Mr. President. But I am not going to dwell at length on all of the particular cases which we have looked at, which I had the benefit and the opportunity from the Law Reform Commission to look at the jurisdictions and the judicial decisions coming out of those jurisdictions. I have presented the relevant data to support the restriction on bail for persons charged with serious offenses, and in particular, data in relation to repeat offenses. Mr. President, I have advised the government that the proposed measures, although they will amount to an infringement of the rights to bail, are proportionate and in pursuit of a legitimate aim. That is to say, to explain the rationale behind the clauses to the bill. 1, to give effect to the ruling in Achille Charles. 2, to give to masters the jurisdiction to grant bail for the offense of murder, a jurisdiction which they did not have at common law and is being created by statute. 3, to provide that right of appeal for the accused or the prosecution against a decision of a judge or master to grant or refuse bail. 4, to impose in conditions on the exercise of the court's discretion. And 5, to impose an enhanced burden on persons charged with serious offenses to justify the granting of bail. In conclusion, Mr. President, this government recognizes that the proposed restrictions do impact fundamental rights and freedoms, but we believe that they are crucial to serve the public interest, and that is in particular to reduce the likelihood of repeat offenders, particularly seasoned criminals, from obtaining bail. We believe that the legitimate aim cannot be disputed of protecting the citizenry from crime. The legitimate aim is to keep our citizens safe. It's as simple as that. And the proportionality introduced in the bill before this House, that is to say, to reserve to the judges the discretion on a case made out to them appropriately by the accused who is applying for bail, who can show sufficient cause or justifiable circumstances to an exceptional degree for them to be granted bail. Those are reasonable, balanced considerations, legitimate for the judges to consider. And in the circumstances, we believe that the bill before this House is constitutionally compliant, albeit with the restrictions, if passed by a 3/5 majority. And in begging to move, Mr. President, I call on the opposition to do the responsible thing. I beg to move.